Since the matters both these matters are interrelated, so a common order has been passed. So I'll just read out certain relevant paragraphs. In view of the aforesaid discussions and taking into account the entire facts of the case as well as the laws laid down by the Honorable Apex Court, this court is of the considered opinion that the order dated 13/12/2024, whereby the learned special judge PMLA Dimapur, Nagaland, directed the execution of the NVWA is not based on the principles laid down by the Honorable Apex Court. In view of the aforesaid findings and the conclusion of this court, the other submissions made by the respective parties are not required to be discussed and or decided at this stage for deciding the instant criminal revision petition. Hence, the same are not considered. In view of the aforesaid conclusion, the impugned order dated 13/12/2024 is set aside and quashed. This court directs the learned special judge PMLA Dimapur, Nagaland to rehear the application, that is IA number 230/2024, on its own merits as per the settled laws, giving an opportunity to the petitioner of hearing. Needless to say that till the aforesaid IA number 230/20/24 is heard, the NBWA issued against the petitioner shall be kept in abeyance. As far as the criminal appeal is concerned, on consideration of the conclusion that has been arrived by this court in the connected criminal revision petition, this court is of the view that the contentions and arguments made in the criminal appeal are not required to be gone into at this stage, as this court has, after hearing the criminal revision petition, already come to a conclusion that the application filed by the respondent ED for issuance of NBWA, that is 230 IA 230/2024, is to be reheard and decided by the learned special judge PMLA. This court has already set aside the order dated 13/12/2024, whereby the learned special judge PMLA directed the execution of NBWA, which was kept in abeyance by its earlier order. Therefore, since there is no active warrant or arrest pending against the appellant, the appellant cannot be declared as fugitive economic offender under the Act 2018 at this stage. Consequently, the impugned order under the instant appeal, that is order dated 22/1/2025, needs to be set aside and quashed. Accordingly, same is set aside and quashed. This court, however, hastens to add that once the application of the respondent, that is IA 230/2024, is heard and decided by the learned special judge PMLA, the respondent shall be at liberty to take action against the appellant under the Act 2018 if the same is permissible under the laws. Since the allegations against the petitioner appellant are grave in nature, which have allegedly affected thousands of innocent investors all over India, it is desirable that further investigation and the trial must be completed at the earliest possible time. Therefore, it is directed that the learned special judge PMLA Dimapur, Nagaland shall rehear and decide the IA number 230 of 2024 within a period of 30 days of passing of the instant judgment and order. Registry to produce and submit a copy of the instant judgment and order before the special judge PMLA Dimapur, Nagaland at the earliest. In view of the aforesaid, the criminal revision number 3 of 2025 and criminal appeal number 1 of 2025 are disposed of as directed.
Clear, please.
May I please, your lordship? Lordship, this is a second bail application, lordship, and he was arrested on lordship 25/7/2000.
What is your new ground?
Lordship, as on today, 180 day, 188 days, lordship,
As on today?
188 days. And statutory is 180 days, lordship.
Lordship, charge sheet here submitted, Lordship.
Just is submitted.
For her instruction, lordship.
Hmm?
Record may be called for, Lordship.
For instruction, Lordship.
Record may be called for, lordship.
Why?
Charge
He's
sheet,
submitting, source is submitted.
lordship.
You require records.
Lordship,
Just is submitted, go appear.
I'm in custody, lordship.
Oh, you are in custody, sorry. You are in custody, source is submitted. Is there any new ground?
I have stated, lordship.
Is there any new ground? I mean, you are in the custody.
Lordship,
What is your new ground?
only on detention, lordship.
Huh?
Only on detention, lordship.
Detention, it's a case of this thing, no?
We were
NCV
indicated
case.
only on the basis of statement of the co-accused, lordship.
Hmm?
Only on the basis of co-accused statement, lordship.
There are sufficient materials, that is why earlier bail was rejected, Lordship.
Where is the order, earlier order?
Lordship, earlier order, lordship, page 39, lordship. Starts from page 39.
You have any details about the charge sheet?
No, Lordship, I am unable to, I couldn't contact with the department, Lordship. He is out of station, Lordship. I know this much, Lordship, that charge sheet submitted, Lordship.
On which date, lordship, if lordship, it was,
Hmm?
on which date it was filed, lordship? Because as on today, 188 days, lordship. If,
You don't have a date.
No, Lordship.
But otherwise, no new ground. See, I mean, that time it was considered
lordship,
and it was a detailed order that has been
lordship,
passed.
detail order was passed.
Detailed order passed and like it was reasoned out why, I mean, there's certain things why.
Lordship, if charge sheet is filed after 180 days, then lordship, probably lordship, default will.
No, it was filed before stipulated period, Lordship. It was filed before, but I don't know the exact time, Lordship. I will, Lordship,
When can you get it?
after some time, Lordship. After
Today?
some time, I
Only one
will,
matter is there.
Today you can get it now,
Lordship. Lordship.
after 10
I'm
minutes.
trying to contact him, Lordship. He is not received.
If you can give me the date, then it can be
Okay.
disposed of. I mean, there is no new ground. Only thing is charge
Only
sheet.
on detention, lordship.
Only detention.
Lordship.
So you can let me know
Lordship.
when the charge sheet is filed. See, if charge sheet is filed, I mean, before the time, stipulated time, then we'll reject it. If it is filed after that, then it will
Or
be,
lordship may direct us to approach before the learned court below, lordship, first.
that liberty will be there, always, will be always there.
If lordship.
So we'll dispose it of, okay, we'll dispose it of in the chamber, I mean, let her get the information. Okay, she will intimate you also about the date. You please intimate him also.
Liberty
and,
may be granted to file before the.
You can always go there. You can always go there. That liberty is always there with you. I mean, without my, this court's any direction or opinion or observation, you can always go there. So, I mean, because you don't have any new ground. Only thing is that detention.
Detention.
So, I mean, you can give me the intimation through him.
Lordship.
You can write it in a piece of paper and like, you please convey it to learned counsel also. That
Or
was
lordship,
filed
I may
also.
be allowed to, if lordship, charge sheet is filed within time, lordship, then I may be allowed to withdraw in that case, lordship.
You want to withdraw then?
Lordship, if lordship charge sheet is filed within time, lordship.
Okay, then, Yeah, how much time will take?
So if lordship rejected, then it will lordship affect us also, lordship, if we file the trial court.
After 10-20 minutes, Lordship, I will.
You just find out when the date was, when it was filed. And if possible, you get the
Date.
charge sheet number and the date, charge sheet number and the date, you get it, okay? Then we'll see what is to be done.
Lordship.
If something is required, then we'll sit again if required. But I think we need not, I mean, if charge sheet is filed in time, then you will withdraw it, right?
Lordship,
Then I'll pass the withdrawal order,
lordship, lordship,
correct?
lordship.
If such charge sheet is filed in time, if charge sheet is not filed in time, then we'll sit again. Then we'll pass an order. We'll call for the, records and all.
Lordship.
Right.
If-
We'll take it up.